Good afternoon, and thank you all for being with us on this beautiful afternoon. This is going to be our 61st annual meeting of the League of Women Voters of the Copper Country. And we are going to begin today with a guest speaker. Let me just say, first of all, about the League that we are a grassroots nonpartisan organization. We neither support nor oppose candidates or parties. We do take positions on issues after a period of study, and we do advocate regarding those issues. So we are open to members. Anyone over 16 can be a member, and if you're not one and you're interested, please be in touch with us about that. We're going to first have our speaker, and then we will follow that with our annual business meeting. So all members who can stay for that, please do. That will help us out with taking care of annual business. Now I'm going to ask Valorie Troche to introduce today's speaker.
Okay, good afternoon, everybody. It's my pleasure to introduce Pat Gottschalk, who is our speaker today. The topic of Pat's talk is the legal process, thoughts on the transition from Ruth Bader Ginsburg to Amy Coney Barrett. Pat attended the National Law Center of George Washington University in Washington, D.C., and received a JD with honors in 1983. She was a member of the George Washington Law Review and was on the winning Van Vleck Moot Court competition team. Many of you, probably most of you, know Pat from when she and her husband lived in Houghton, where Pat worked for legal services and also for Michigan Tech. She and her husband retired to Maui several years ago, and although retired, Pat retains her interest in law and has closely followed the recent changes on the Supreme Court. When Pat is done, there will be a short time for questions, and I think you can, I don't know exactly how many people are on, but you can either ask the questions or type them into the chat if you prefer. So welcome, Pat, to the Copper Country.
Am I muted? Am I okay now?
You're okay now.
Oh, okay. Hi. I don't know if you heard anything I just said. Thank you, but thanks very much. And I'm looking forward to, first of all, it's nice to see everybody. And thank you for asking me to speak. This isn't going to be a comprehensive review, obviously, of everything that Ruth Bader Ginsburg has done, because that would be a university course and not a 30-minute talk. But what I did is I looked at a couple things that raised some interesting questions and which may be answered eventually as the years go by. I first gave this talk in January to our local AAUW group, and since then there have been a few developments. So, so I've tweaked it to bring in some of the new things. Amy Coney Barrett, she had been a judge on the Seventh Circuit Court of Appeals for about 3 years when she was nominated. After law school, she clerked for two judges who were deemed to be very conservative. One is Judge Lawrence H. Silberman of the U.S. Court of Appeals for the District of Columbia in 1997. And then she clerked for Justice Antonin Scalia of the U.S. Supreme Court in 1998. And I won't go into the Senate confirmation process, but as is the tradition for confirmation hearings, then Judge Barrett would not respond to questions about how she would rule on specific types of cases. Because she had a very short tenure on the Seventh Circuit, there were not many opinions to look at to get a sense of her judicial philosophy. Social media and commentators expressed concern that she'll destroy the legacy of Ruth Bader Ginsburg as a champion of women's rights. So one could question is, will her purported religious values outweigh the law? She did have several law clerks working for her during her tenure on the Court of Appeals. And one female clerk who was interviewed said, Justice Barrett was always good at listening to all sides of the argument and looking at the argument from all angles. And when asked if she saw Barrett as a conservative judge during her clerkship, the clerk said, I got the sense she's a judge who takes her fidelity to the law very seriously. She's committed to being a judge. So we have that background. So what impact will she have on the Supreme Court? She's very young. I mean, by judicial standards, she's young and will likely be there for quite some time. It's interesting, Judge Souter, who people may remember, Justice Souter, when he was nominated and later confirmed, he was picked by George H.W. Bush in 1990. He was upheld as a conservative justice, but after he got on the court, he became very liberal. Some say it's because retired Justice Brennan took Souter under his wing and made a particular point of mentoring him, either out of courtesy or perhaps because Justice Brennan, who is very liberal, had a hidden agenda. But again, it's hard to predict how someone may behave or be later on in their judicial career. So what we'll do now is we'll look at some philosophical and legal issues in an attempt to compare and contrast Justice Barrett with Justice Ginsburg. Obviously, I don't have a crystal ball and I don't know how accurate any of this will be. She hasn't authored many cases this term, but there are a few we can discuss or authored or done. Let me show you this real quick. One interesting COVID fact is that the Supreme Court hasn't met, at least as a group, to get a new photo. If you go to the supremecourt.gov website, there's no updated formal photo either of the court, the full court, or of Justice Barrett. So we have the formal photo here has Justice Ginsburg still on the court. And we have Sotomayor, the female justices are Sotomayor, Kagan, and in that case, Ginsburg, but now Barrett. And then we have Thomas, Breyer, Gorsuch, Alito, Chief Justice Roberts, and I know I'm missing somebody here. Breyer, Thomas, Gorsuch, Alito. Oh, Kavanaugh, of course, Kavanaugh. So, so obviously Justice Ginsburg is no longer there. Okay, let me first start. This is what I'm going to try to cover. I may go a little fast and I'll try to leave plenty of time for questions. First of all, judicial philosophy, the difference between originalism or loose construction, getting your case into the Supreme Court, because that's one way that a new justice might affect the court is how open they will be to allowing cases to even be heard. There's many judicial principles that courts can use to avoid taking cases. And I'll touch on a couple of substantive legal issues, privacy and religious freedom. Obviously, there's a lot of other things we could talk about. But first of all, you may have heard the term originalism or originalist with regard to Justice Barrett. What does this mean? So basically, when making a decision about how to interpret the US Constitution, there are a couple schools of thought. I'm simplifying this because, as always, there are many shades of gray. But an originalist, and Barrett, I think, falls firmly in this camp, believes that the original meaning of constitutional words and phrases are fixed at the time of ratification, which was 1787. This original meaning of the terminology controls the judge's decision-making because it and it alone is the law. So the judge's role is to look at the language, look at the controversy in front of the judge, and apply the original public and historical meaning, meaning the meaning at the time of ratification by the framers to the controversy to reach a decision, as well as looking at persuasive legal precedents. So some people view originalism as being viewed as a conservative approach to interpreting the Constitution. Some use the word textualist. I'm going to quote now from a judge that never got confirmed to the Supreme Court, Judge Bork. His statement about originalism, since he was a conservative judge, if the Constitution, this is his quote, if the Constitution is law, then presumably its meaning, like that of all other law, is the meaning the lawmakers were understood to have intended. If the Constitution is law, then presumably, like all other law, the meaning the lawmakers intended is as binding upon judges as it is upon legislatures and executives. This means, of course, that a judge, no matter on what court he sits or she, may never create new constitutional rights or destroy old ones. Anytime he does so, he violates not only the limits to his own authority, but, and for that reason, also violates the rights of the legislature and the people. The philosophy of original understanding is thus a necessary inference from the structure of government. So in other words, what the originalist camp believes is that loose interpretation of the Constitution is anti-democratic because you're taking away the role of the legislature, and in some cases the executive. So that's the originalist viewpoint. Now, the other side of the coin is, you can call them loose constructionists or gap fillers, and Justice Ginsburg was in this camp. They consider the Constitution's original meaning to be a relevant factor in interpretation, but other factors like value-based judgments and more subjective considerations, such as sociology, psychology, other non-legal data, can come into play. So the Constitution is more of a living, dynamic document. There's a famous judge, Richard Posner, who sat on the Seventh Circuit. Ironically, he was appointed by or nominated by a Republican, but he actually wasn't necessarily viewed as being super conservative. In any event, here's a quote by Richard Posner about the idea of why the Constitution should be viewed as a living document. And it ties in with a case called Griswold versus Connecticut that we'll talk about more in the, later on, which was where rights to privacy were discovered in the Constitution. It had to do with contraception, a law in Connecticut that prohibited married couples from purchasing contraception. So here's what Judge Posner says: a Constitution that did not invalidate so offensive, oppressive, probably undemocratic and sectarian law as this Connecticut law about contraception would stand revealed as containing major gaps. Maybe that is the nature of our, or perhaps any written constitution, but yet perhaps the courts are authorized to plug at least the most glaring gaps. Does anyone really believe in his heart of hearts that the Constitution should be interpreted so literally as to authorize every conceivable law that would not violate a specific constitutional clause? Okay, so to make the first comparison between Justice Ginsburg and Justice Barrett, since Justice Barrett purports to be an originalist along the lines of the late Justice Scalia, it's unlikely in the future, we'll see what she really does, but it's unlikely that she'll be creating unwritten constitutional rights or relying heavily on external values in interpreting the Constitution. Whereas I think Justice Ginsburg was more likely to feel comfortable filling gaps. So we'll see what happens. So another possible difference between the two is their view on the access to the Supreme Court. Just a quick refresher, the Constitution only allows federal courts to hear cases and controversies. They're not allowed to issue advisory opinions. So in order for litigants to get their day in federal court, they must have suffered some kind of real injury. So they can't just be asking for an advisory opinion. They have to have a real injury and a real stake. Like everything else, this can get fuzzy when actual cases come to court. But there's ways that the federal court can avoid taking a case. There's doctrines called ripeness, which is the case ready to be heard. Mootness is the case already over. We don't need to hear it because it's over. Standing, is this the right plaintiff? Do we need a different plaintiff? And then just general prudential considerations like whether something's a political question, or this also gets into the interpretation of whether the court should be punting this back to the legislature rather than taking something up on its own. So I'm going to talk about a mootness case, and this is the COVID case, one of the first COVID cases. And there's been a whole line of decisions recently relating to COVID and religious freedom, which are kind of interesting. So this is one that Amy Coney Barrett participated in. It's called Roman Catholic Diocese of Brooklyn versus Cuomo. It was November 2020. Justice Ginsburg passed away before this case, but I expect she probably would have followed the what Justice Sotomayor will say about this in a minute. Okay, so I'm going to cover it because it's timely. So the issue was First Amendment and religious freedom, but also the issue of mootness. So the facts were that there was an emergency application by a synagogue and a church for relief from restrictions imposed by Governor Cuomo on the number of people attending services due to COVID. In red zone areas, no more than 10 individuals could attend in houses of worship, but businesses categorized as essential could have many more people in their place of business. So the religious groups applied for injunctive relief pending an appeal from the Second Circuit. So basically the Second Circuit had upheld what Cuomo did, and the religious groups wanted an injunction to basically set that aside pending an appeal. And so what happened was there wasn't a formal opinion because it was an emergency petition. There was something called a per curiam unsigned decision, but there were some written statements by the justices. The Chief Justice said the case is moot because in the meantime, regulations were amended to change how the number of congregants were calculated. They went to a percentage of the size of the congregation. I can't remember if it was 25% or 30% or something like that. So basically Justice Roberts said, well, there's no case or controversy because the rule that the religious organizations are fighting against no longer exists. So that's one way of saying the case is moot. The majority, though, and Amy Coney Barrett was in this group along with Alito, Kavanaugh, Thomas, and Gorsuch, said that the case was not moot because the regulations could be reinstated at any time. So they said there was a case or controversy. And in the written decision, they said the court is not a public health expert, but even in a pandemic, the Constitution cannot be put aside and forgotten. So there was deference to religious freedom, and they basically agreed that the injunction could be granted. And so the rule that actually no longer existed, but the rule about 10, a limit to 10 people per congregation was eliminated or was stayed. There was another case that happened much more recently on April 10th called Tandon versus Newsom. And this is from the state of California. In this case, the state of California had a law that restricted gatherings inside of private homes to members of 3 households. Actually, and that had to be out of doors. There was absolutely there were 100% restrictions on indoor meetings, but you could have 3 households at outdoor meetings. The same rule applied to prayer groups, religious meetings, as well as other public meetings, like, if you had a board meeting in your house. So private and religious were handled the same way. Again, a per curiam decision, and this was an unwritten decision, an unsigned decision, except for some people signed their own separate statements. The majority said that the public businesses, not in private homes, but public businesses outside of private homes were treated more favorably than private homes, and that therefore this was a violation of the First Amendment, or could be, religious freedom, freedom to gather and pray. The dissent said the comparison shouldn't be between private gatherings and public businesses, that it should be between private gatherings that were religious and private gatherings that were not religious. The majority said that if you want to restrict religious activity at all, you have to show it's more dangerous than other activities, even with the same precautions applied. The dissent said, well, there was actually something in the record about that in the district court, that in private homes, it was much more likely that people wouldn't be wearing masks. It was hard to enforce, et cetera, et cetera. But nonetheless, the court decided that the preliminary injunction would be granted. And so that rule by the state of California was set aside. The dissent actually was Sotomayor, Kagan, and Breyer, who are the 3 liberal justices. Roberts joined that group, but without a written opinion, Chief Justice Roberts, but again on the basis that this was moot because the rule had been changed again in the interim. So Roberts, Chief Justice Roberts is basically not wanting the Supreme Court to get involved in things where the public officials are making judgments about public health. So he said it's moot, we don't need to get involved. So it's been in that particular case though, since Amy Coney Barrett was there, arguably if she hadn't been there and Justice Ginsburg had still been there, it would have been 5-4 going the opposite direction. If you assume that Justice Ginsburg would have gone with Sotomayor, Kagan, and Breyer. So that's a case where Amy Coney Barrett's presence on the court actually changed the outcome, arguably. Now, there are 2 other cases, again, involving COVID, where Justice Barrett did not go quite as far as other conservative members of the court. The first one is South Bay United Pentecostal Church, again, versus Newsom, because it's another California case. Basically, this had to do with another one of these restrictions on indoor gatherings in public places. But Justice Barrett agreed that the prohibition on singing in church was something that there was enough in the record below, enough in the evidence to support that singing and chanting was more dangerous than in a church setting than not singing and chanting. So she agreed that the injunction should be imposed to allow congregations to meet, but she felt there was enough in the record to prevent singing and chanting. And a couple other more conservative, more liberal justices went along with her on that one. Whereas Justice Gorsuch said he would have set aside all restrictions. He would have allowed singing and chanting. And so, so in this case, she didn't go as far as a fellow conservative justice. She looked at the record and said, well, there's evidence that singing and chanting is potentially dangerous. So there you go. That's one example of where she didn't stick with the most conservative. There's another very interesting case that actually involves the death penalty. This is the last COVID case I'm going to talk about, Dunn versus Department of Corrections, and this is in Alabama. Basically, this is the outcome on this one's going to be a little different. Alabama law prohibited anyone entering the death chamber during an execution, including the prisoner's pastor. The 11th Circuit Court of Appeals enjoined the execution because there's a statute called the Religious Land Use and Institutionalized Person Act that gives rights to religious observances to prisoners. So the 11th Circuit basically prevented the injunction, the execution, because the prisoner couldn't have his pastor there. The Department of Corrections went to the Supreme Court on an emergency petition and asked for the injunction to be set aside. And in this case, it was interesting that 4 justices said that they would have set aside the injunction, in other words, allowed the execution to go forward. Justices Thomas, Kavanaugh, and Roberts, and one other justice. They all didn't have to sign on because it was, again, one of these per curiam opinions. Interestingly, though, and the reason that they thought that it was okay to execute this individual without his pastor was because there was a compelling state interest in safety. Although Kavanaugh and Roberts also said it'd be nice if the legislatures, the state legislatures, could figure out a way of allowing the pastors to come into the death chamber. But as it was, they said the state showed there was a compelling interest in safety. Justice Barrett, interestingly, joined the liberal wing in this case, Breyer, Sotomayor, Kagan, in refusing to set aside the injunction because in balancing the need for prison security against the sincerely held religious belief of the prisoner. And since there was no evidence of anywhere any clergy person causing a disruption in any death chamber in any state, they felt that that the pastor should have been allowed. So that was an interesting case where Barrett joined the liberal justices, because I would guess the liberal justices were in favor of prisoners' rights. So the conservatives in this case, was interesting. The conservatives in this case didn't want to second guess the state's view on what is a safe activity, whereas the same justices, most of them in COVID cases, were very willing to second guess the state's judgment on a safe activity when it dealt with COVID and religious freedom, as opposed to COVID and prisoners' rights. So I thought that was kind of interesting. There were two justices that didn't publicly disclose how they voted, but because it was noted to be a 5-4 decision, one of them would have gone with the majority and one with the dissent. But this is kind of interesting, I think, because it shows that, again, you say there's a conservative wing and a liberal wing, but sometimes they mix up a bit. And there've also been decisions, not on these controversial cases, but there've been unanimous decisions that this court has done this term, as well as decisions with like only 1 or 2 dissenting justices. Okay, I'm going to move now. I'm not keeping, I may be running a little long here. Just stop me if I'm running into your time. I'll go as far as I can. Future cases on women's rights and reproductive freedom. Let me just quickly say there is a doctrine called stare decisis, which means if the law is settled, the judges shouldn't be changing the law willy-nilly unless they have a pretty good reason to do so. And even originalists believe in stare decisis to a point. And such as a decision like Brown versus Board of Education, they view that as what's called a super precedent, something that would never be overruled. Obviously, that's the case, the separate but equal case, that where they said separate is never equal. That case will never be overruled. It's called a super precedent. But what about the abortion rights cases? Are they super precedents? Actually, originalists don't see these as super precedents because they say there's a continuing controversy about reproductive rights. So this obviously was a big issue when Barrett was in her hearings, but she wouldn't really say, what she would do. So we have to look at what her writings have said. She did write a law review article when she was a professor, basically saying that stare decisis sometimes needs to be not held up as if it is completely contrary to the interpretation of the Constitution. And she did, people got a little nervous when she was saying that, for reasons, because there was concern that she would feel that, something that relied on the privacy right, which I should describe that the privacy right is not a right that actually appears in the Constitution. There is no word that says privacy in the Constitution. The privacy right was sort of discovered in the Griswold versus Connecticut case, that contraception case, because the court found that the couple's right to contraception stems from a penumbra or zone of privacy emitting from the Bill of Rights and the First, Third, Fourth, and Fifth Amendments to the Constitution, plus that the Due Process Clause protects liberties that are so rooted in the traditions and conscience of our people as to be ranked as fundamental. So Griswold created, in a sense, a privacy right, and an originalist that would just be anathema to an originalist. So people are a little concerned to the extent that any of these reproductive rights cases are based in privacy, that Barrett might be willing to set them aside. So that's a possibility. Some of the newer cases on reproductive rights also rely on equal protection analysis, and so that may prevent them from being overruled. If they were only based on privacy, it might be more of a problem. But also, it's interesting that even privacy, the idea of contraception being a married couple's marriage, what's going on within the marriage being considered to be covered by a privacy right. A little slightly different spin, but you may have heard the Hobby Lobby versus Burwell case. That was when Justice Ginsburg was still on the court. That was the case where there was a company, Hobby Lobby, that isn't a corporation. It's a closely held family company, even though it is a large company. It has crafts, big crafts, things like Michael's, big craft stores. Anyway, the Hobby Lobby owners said that they had sincerely held religious beliefs that made it impossible for them to provide certain kinds of birth control through the insurance that their employees had. Any kind of a birth control that would be seen as causing an abortion, like an IUD, in their medical opinion. So the court upheld that, that they said that there was sincere belief and that there was a religious liberty impacted here. And that, you know, in balancing everything, it was the religious beliefs of the owners of the company overrode the rights of the employees to get that kind of insurance. Ginsburg stated in her dissent in this case, she disagreed and she said, "Your right to swing your arms ends just where the other man's nose began." So basically, Ginsburg's view of religious freedom is not as strong because she dissented from the Hobby Lobby case. There was another very recent case that because it was January 12th, 2021, Ginsburg was not involved in this, having to do with these same kind of medically induced abortion medications called Food and Drug Administration versus American College of Obstetricians and Gynecologists. Again, it was January 12th, 2021. So this is kind of an interesting case. The former administration basically initiated a rule through the Food and Drug Administration requiring patients who needed the drug, it's called mifepristone. It's an abortifacient drug. In order to get it, the patient had to go to the hospital or a clinic. They had to walk in to a building with a prescription and pick it up. Of the over 20,000 FDA approved drugs, mifepristone was the only one that the FDA required to be picked up in person. So again, during the COVID crisis, somebody filed a request to the district court that this FDA rule be set aside because it was dangerous for people to go into hospitals, or in some cases they wouldn't be allowed to go into hospitals or clinics to pick up the drug. The FDA appealed the order because the district court struck down the rule, but then the FDA, still under the previous administration, appealed the order and requested a stay pending appeal. So the Chief Justice of the Supreme Court, Justice Roberts, said that they weren't looking at an issue about burdening the right to terminate a pregnancy here. They were looking at whether the district court properly ordered the Food and Drug Administration to lift these established requirements because of the court's own evaluation of the impact of the COVID-19 pandemic. So basically, Roberts said he's going to allow the FDA's rule to stand because he's not going to second guess the FDA in their interpretation of medical necessity, whether it's really medically necessary to pick that drug up at the hospital. So there were, again, 3 justices dissenting. In this case, it was Sotomayor, Kagan, and Breyer. If Justice Ginsburg had still been on the court, that would just have added 1 justice. So it still would have been a 5-4 decision. So it wouldn't have changed. But interestingly, the current administration just set aside the FDA rule just last few days ago. Biden's FDA has suspended the in-person requirement to get medication for an abortion. So that is now, it is truly moot at this point. But again, it's interesting if you look at all of the cases involving COVID and whether or not the justices are going to second guess the state's interpretation of the public safety or public health, or in the case of the FDA case, the federal government agencies evaluation of balancing public health versus risks in the COVID case. The conservative justices were okay with substituting their judgment about the size of church congregations, and they didn't show deference to the state for the most part. But in the abortion case, the conservative justices deferred to the FDA, even though arguably it does burden abortion rights. And then in the death penalty case, the conservative justices were, most of the conservative justices, but not including Barrett, were willing to let the execution go forward. It wasn't a COVID case, but it was the idea, again, of balancing religious liberty against other rights. So it's kind of interesting how they're not being 100% consistent about whether they should substitute their judgment for the legislature, or the FDA, the executive branch agencies. So that's sort of the end of it. In conclusion, I'd say good bet that Justice Barrett will be a staunch defender of religious freedom. I would say she's probably much less inclined than Justice Ginsburg to step in and fix gaps in the Constitution or perceived gaps.
You're somehow muted. There we go.
Yeah, how long? I'm not long, right? Okay, well, I'm pretty much done. So basically in some, I'm just waiting to see what happens next. I mean, there'll be more cases. We'll hear more from her. It'll be interesting to see what happens when the Supreme Court can start sitting together, and they're probably Zooming like everybody else right now. It'll be interesting to see, if they start meeting in each other's chambers and having chit chats, and maybe Sotomayor and Kagan will take Barrett under their wing, and who knows? We don't know what's going to happen. There's no obvious retirements in the conservative wing of the court. None of them are really that old that there's an expectation that anyone's not going to live through the first Biden term. However, I would guess it's likely that Justice Breyer will retire at the end of the term so that President Biden can nominate a new justice. That's my guess. I mean, obviously, I don't know. So that's it. If you have any questions, comments, I'll stop sharing now.
I have a question.
Sure.
Hi, Pat. Thanks for that. I really learned a lot.
Oh, hi, Faith.
So I have a comment and a question. They're on two different things. You noted that Barrett, her decision was against her originalist philosophy, hypothetically, but that it found her taking allies with the liberals. But actually, she was acting consistently with her Catholic theology, which is against execution. So I wonder, just as a comment, to what extent what is the appropriateness of finding your rationale based on your own personal religious beliefs rather than on the law?
Well, and that's going to be the question, because you can always, there's plenty of law out there that people can draw upon to justify a decision. But you raise a good point. I didn't. Yeah, it wasn't just that she is a Catholic, but there are a lot of other Catholics on that court. Actually, it's heavily Catholic right now that went the other way. So yeah, it's hard to say. I mean, it's an excellent comment. Her law clerk, again, I can only say what her law clerk said, which is that she does look at the law and looks at the case, and that's what the law clerk says. And I would say, my opinion, and I know this is being recorded and everybody can get all over me, I think Justice Alito is the most political of the justices. I think he's the one that he wears it right on his sleeve. He comes out and, he gives speeches. Not that that is unusual now, but he's extremely politically motivated, I think. Whether Justice Barrett will be more circumspect, in the future about giving talks or signing petitions or, the kinds of things that were brought up in her confirmation hearing.
My other quick question was, you said that Brown versus Board of Education was a super precedent, and how do you get that designation?
It's not a legal designation. It's probably the sort of thing that academics in law review articles, I didn't delve into it very deeply, but I suspect it's something that academics over time in law review articles, or maybe I should Google it. The term may even appear in a legal opinion somewhere. But this was something I read in one of the things I read getting ready to prepare this talk and I can't remember if it was a law review article or if it was some law firms do analyses. I can't remember where it came from, but the idea of Brown being board being untouchable by anybody versus there were other cases that are not given that same, probably Marbury versus Madison might be another super precedent that nobody would ever touch, but there are not many of them.
Thanks.
See, were there any chat questions?
So I have a question.
Yeah, hi, how are you?
Question. This is Pushpa.
Hi.
Good, thank you. So hi Pat, what do you mean by he's political? What do you mean?
Well, what I'm saying is that his background, I don't have it right in front of me, but he came into the court with a very political background. Now I could Google it real quick. Maybe you all could Google it afterwards, or I could. He was heavily involved in politics, is what I was saying, and he just doesn't seem to be shy about even in his opinions, kind of harumphing, I guess I would say, about how he feels about things. And Justice Thomas is getting that way a little bit too. And people have said, well, he's married to somebody who's very active in GOP politics, and some people are criticizing that. But of course, in Washington, it's a small, very, very incestuous community, so that's probably hard to find. I'm just trying to remember if there was something specific about Alito, just stuff I've read. When I read his opinions, I just kind of think, he's just kind of saying how he feels from a political standpoint. But I could be wrong about that too. I'll try to look and see, Pushpa, if I can find something specific, I could email it to you.
Okay, thank you.
We have a question from Jackie.
Hi, Jackie.
Jackie, can you unmute yourself?
Sure. I have satellite internet, so it's always iffy if people can hear me. But my question was, could we ever invite you back and have you talk about Kavanaugh as well? Because he's still kind of an unknown to me, at least.
Yeah, he would have more of a record because more of a history because he sat on the Court of Appeals for the District of Columbia. I didn't research his background. Obviously quite a bit came out in the hearings. I don't know who he clerked for in the past. I really don't know very much about his background, but it's easy enough. He joined Barrett in that business about the singing. He joined Barrett in the sort of not going as far as the other conservatives went in terms of saying singing and chanting. There was something in the record to support that was more dangerous. I'd be sure, I'd be happy to take a look at what he's doing, what he's done and what he did in the past. I can't remember how long he was on the Court of Appeals and whether he had been on even a district court prior to that. I just don't remember. He's also very
It's
young.
great.
He'll be young. He'll be there for a long time, most likely.
The next person is Nancy Herc. She'd like to ask a question.
Sure.
Yeah, I don't like the fact I'm an unchurched woman for a lifetime, and I don't like the fact right now that essentially the court is a proxy for the Catholic Church. I don't wish to be lectured on morality by such people. I think they lack intellectual rigor. And also there's the problem of the Federalist Society. How do we break their influence? No, these people are not, to my mind, judges. They're ideologues.
And that's a very good point. And I'll have to go and look. I think Justice Alito was one of the darlings of the Federalist Society, as well as the judge, that Barrett clerked for in the Court of Appeals, Justice Silberman. He was well loved by the Federalist Society. There's some ideas out there right now that I think are kind of interesting. One is court term limits.
Yes.
A lot of the problems with this, with things being so crazily political. You'd only have to go back a couple decades where even like someone like Justice Souter, who was nominated by a Republican, I think he probably sailed through his confirmation, because he had pretty good record, just intellectual vigor and, having been a judge and all those things. So term limits might be one way to, and I think you'd have to amend the Constitution though, because my recollection is that the lifetime tenure is actually in the Constitution. So that could be a little dicey in today's environment. Of course, there's talk about adding 2 justices to make up for what people perceive as, kind of shoving Kavanaugh and Barrett in, what some people perceive that as that. And
Actually, 4 justices just Ed Markey and his crew now want to put 4 more on. We have a 13 justice court.
I mean, you could do that because the size of the court is not in the Constitution. That's a federal statute and Congress can address that. So that's another possibility. I mean, I personally just wish that elected people cared more about intellectual rigor rather than politics and ideology, because ultimately, but it's not like this hasn't happened before. I mean, I'm no scholar, so I don't remember the history, but there have been plenty of people stuck on the court way back in the day that were political hacks. I'm not saying anybody on the court now is a political hack, but I'm saying it's happened in the past. But I lay a lot of blame to social media. It just seems like everything's gotten so politicized and hysterical, everything.
Well, there's
Yeah.
also the fact that the law and justice seem to be so different from each other. All we have to do is look at what's been going on, since Trump got elected and now he's out, thank God. But think of how many things, well, this is what the law says. And in your heart, it's not what justice demands.
And the reason I named this talk the legal process was because one of the best classes I ever took in law school was called the legal process. And it was looking at exactly that government is a dance between the 3 branches, basically, the judicial, the legislature, and the executive. And there's ebbs and flows of power, and there's ebbs and flows. Like right now, the executive branch is very powerful. And that's kind of been since the atom bomb. People say it started with the Cold War. Very strong executive. And maybe that's not so good. Maybe the Congress needs to be stronger because that spreads it out more.
Yeah.
You don't get somebody at the top. And frankly, the judges have been pretty good. If you want to look at the courts all over the country, have been pretty good about looking at the law very carefully and following it with the election cases.
Yep.
So they kind of, they stepped up to the plate. So yeah, it's an ebb and a flow. It's an ebb and a flow. And, a strong executive, maybe, people could say that maybe that's not such a good thing in either party, for people to be ruling by executive orders rather than the legislature. But Congress has got to step up too. I mean, Congress has been abdicating its power or giving up its power, which is dumb, in my opinion.
Yep, I agree.
In my nonpartisan opinion.
Yeah, believe me, agree with you on that. And thank you very much for this talk. It was lovely.
Thanks.
So I want to add something to what Nancy just said. And Nancy said a few minutes ago, whenever people talk about their Catholic faith or Protestant faith or something, me being neither a Catholic nor a Protestant, I squirm. Because I say they should put to Hindus, to Muslims, to of every religion, if
or
it's
no
okay, and atheists and everything, because otherwise, sometimes talking as if letting their religious beliefs guide their judicial decision making for us who are not of the majority religion is unacceptable. It should not be okay. But everybody talks about it like it's okay. How many Catholics, how many Jews, how many Protestants? Anyway.
No, I mean, I think a really interesting thing about the fact that religious freedom in the First Amendment has been getting so much traction is religion isn't like an immutable characteristic, like, to some extent your gender, it's not that immutable, but the color of your skin may be considered immutable, but religion isn't. I mean, you can change religion. And what is a religion? I think the court has really ducked that issue. What is a religion that is given deference? I mean, we could all cook up some pretty interesting religions if we wanted to. I remember the college campus had the Pastafarians and, a sincerely held religious belief. Well, I remember prisoner rights cases where the prisoner said, I have a sincere religious belief that I have to have surf and turf on Friday night for dinner. I mean, so I don't mean to be to not be taking religion seriously, but religion is kind of a concept that can be very different depending upon, I mean, there's thousands, there's probably tens of thousands of religions. So how is the court going to balance, you know, one religion against the other religion? That's going to come up at some point.
Pat, there's one more question asking what your thoughts are about having a commission on Supreme Court revision.
That's a good idea. You know, a bipartisan commission, and also bringing in experts. I think expertise is really important, and bringing in experts from, you know, academia and from social justice organizations and from the bar associations, you know, police in some ways may have a stake, lots of different people. But yeah, I think that's a really good idea, because I know Nancy Pelosi said she's not going to put that. Somebody's already introduced a bill to try to expand the Supreme Court, and she said she's not going to put it, do whatever they do, put it on the floor for a vote or whatever, or put it in a committee or do whatever they do until there's a commission. So that seems like a good thing. You don't want to be tinkering too much, you know, out of without thinking it through. Yeah.
Horst, did you have a question? You want to unmute yourself?
Yeah, I was wondering, you know, with the country being divided about half and half in conservative and liberal states, do you see anything coming out of all of these voter suppression laws that we're seeing?
Well, I'm no expert in that area, but I would say there's a guy who I follow his website, Mark Elias. He was one of the attorneys who was involved in almost all of those cases on behalf of folks that were trying to prevent voter suppression. And I think his website is called Democracy Docket. And he's a real expert. I mean, he is the expert of experts in voter suppression. So I would strongly recommend, if you're interested in that, to look at Democracy Docket. I'm pretty sure that's what it's called, or Mark Elias. It's MARC and then LELIAS, I think, Mark Elias. But yeah, what happens often in legislatures, it gets this legal process thing again, where, you know, legislatures sometimes grossly overreach. They pass laws because it feels good and they get voters to get excited, but they're unconstitutional. And then they can harumph and grump and say, well, we want to pass this law, but the darn court, you know, blah, blah, blah. You know, they do it on purpose in a lot of different situations. They do it in abortion cases, as, you know, the very hyper strict abortion laws that they know are unconstitutional. They pass them anyway, so they can get the votes, they get the public all riled up and but then the courts will throw them out because they're so blatantly unconstitutional. So yeah, I think it's very good, you know, since I'm in favor of as many people as possible voting. You know, most people, I think, feel the same way, hopefully, particularly for the League of Women Voters, that most of these things that are so egregious, although who knows, I don't know, they might try to pass something that has 5 really horrible things, but one not so horrible, but still bad. And somehow the court will throw out the 5 really horrible things, like you can't give people water in line, but leave something else. The ones that scare me the most are the ones that give the legislature the right to basically overturn the will of the voters. And that sure sounds unconstitutional to me, but Mark Elias is the expert. So I strongly recommend his website for, and you can get on his email list and stuff and get updates.
Faith Morrison, we'll give you the last question, please.
So Pat, I had another question that you had mentioned. We talked a little bit about the Supreme Court and term limits of, you know, as a potential resolution and adding members. Am I mistaken, or is it that I think the life appointment in principle was meant to insulate the justices from political sways left and right? Can you comment a little bit on that and how it's now turned into something a little bit different?
Well, one thing to get back to the term limits is they're looking at really long term limits, like 15 to 18 years. So it's not like a 4-year term. It like, you have with, or a lot of states have term limits for their representatives. So they're thinking if they have really long term limits, the justice can be there long enough to learn how to be a justice. But yet when they're being nominated, the thought is that neither side's going to say, I've got an ace in the hole for the lifetime of this person. So they're thinking, well, maybe that'll help. But yeah, I mean, it ultimately gets down to the process of nominating a justice. And also the fact that it's gotten so politicized, but it was politicized back then. Remember Earl Warren? There was this whole impeach Earl Warren movement back in the day. He was the Chief Justice. He had been the governor of California. And then he went on the court and they thought he was going to be conservative and he turned out to be very liberal. I remember this because I'm old enough to remember it. And there was this whole impeach Earl Warren. You can't impeach a Supreme Court justice. That's happened, or the threat of it has happened. You can get rid of them that way. But yeah, there's no perfect solution, I guess, to avoiding politics when everything is viewed through a political lens the way it is now.
As you said, though, I think that our history shows that that's usually the lens we actually use.
Yeah.
And so I'm always looking for various examples of how things turned out so we can see which thing we should do these days to bring us back to a functioning, conversing, compromising and listening sort of a society that we hope ourselves to be.
Well, start with the youth, right? Teach the youth. Voter turnout drives are great. We don't have a League of Women Voters on Maui, but we have other groups that, getting kids to vote, getting kids interested in politics and not thinking that politics is dirty and horrible. I mean, it's sad that that there's been so much negativity about government, that everyone says government's bad, government doesn't know what it's doing, blah, blah, blah. It's too bad that if people had more faith in government, maybe better people would run for office. I mean, I still I hate to sound like an old lady, but social media, I think, has really been a curse in many ways.
I'm going to jump in here and say, we do have Carolyn Weisbach with us, who's president of the the Copper Country
Bar Association.
Sorry, I blanked there. Carolyn, do you want to finish us off, please?
I just wanted to add to something Pat had said, and thank you, Pat, was that bar associations do play a role in the advisory process with respect to selection of justices. And for those who may not know, that here we have a Barriga-Houghton Keweenaw Tri-County Copper Country Bar Association here in the Copper Country that is comprised of members of the bar that includes attorneys, prosecutors, judges, and so forth. So thanks for the opportunity to plug that.
Thank you. Thanks so much, Pat, for being with us at the break of day for you.
Oh, yeah. And if anyone's ever on Maui, be sure to look us up. Lori knows where to find us. So, okay, take care, and thank you for letting me speak with you.
Great
Aloha.
program.
Aloha,
Thank you.
kako.
Aloha.
Let's take a 3-minute comfort break, and then we will reconvene to do annual business.